Hello, everyone. Let's start. I would like to welcome and thank everyone for joining us on today's conference. This is the third and the last session of this event on this conference on actual issues of employment law. Part of today's participant, I think, may have had some opportunities to listen to my colleagues from other offices of Grata. Let's start with the introduction of myself. I'm Sofia Ruinishvili. I'm a partner of Grata International in Georgia. For them who might be interested, Grata has actual presence in Georgia from 2017. Grata is an international law firm operating in 20 countries, covering mostly CIS, post-Soviet countries, and Eastern Europe. More than 250 professionals provide legal services to international and local firms, such as banking, insurance companies, and different businesses engaged in transportation, light and heavy industry, financial sector, telecommunication, pharmaceuticals, and etc. The firm has started its activity 28 years ago. Reputation and professionalism of its lawyers are recognized through reputable agencies such as rating agencies, such as Legal 500, Chambers and Partners. So you can look through the website of this rating agencies and find comprehensive information for each office of Grata International. Employment practices itself in Grata cover full range of legal services, starting from drafting sample HR documents such as sample labor agreements to representation the clients and the employment disputes. We also advise our clients with respect of labor and tax issues related to employee stock ownership plans. Our offices may offer also services in optimizing work process in their companies during pandemic and economic crisis right now. As the firm is represented in 20 countries, clients of Grata have a great opportunity to apply directly to the offices in their home countries, and the inter-office teams will help them to receive services from different jurisdictions. So this is a one-stop shop convenient feature for all of our clients. And right now, let me just explain how our today's conference will work. Will be organized. There will be 3 topics about which our speakers will talk. After introduction, there will be a brief presentation from our side, from Georgian office side. It covers it covers migration law and employment of foreign citizens. After there will be presentation from Mongolia office. Polorma Valodia, partner from Mongolia, will talk about action during COVID-19 pandemic, and this part of this conference will be closed by Baku office, representative of which will Shabnam Sadigova will talk about challenges and common mistakes by employers during the termination of employment agreement. So each presentation will take approximately 15-20 minutes. After the conference, after the presentation part is over, there will be part of questions and answers. So I encourage everyone who have a question, who has any question, just during the session, send the questions directly through the chat or questions and answers. And later we will have another 30 minutes during which our lawyers, speakers will answer to all questions you are interested in. So this is the organizational part of our conference, and right now let me start with the presentation from the Georgian office, and just a minute, I will open the presentation itself. Okay, let me start with explanation why we have chosen this topic. From our experience, it's the part of our experience that shows us that some of our clients are quite often interested how migration law and employment law applies to foreign citizens employed in the territory of Georgia. Generally, this subject is mostly regulated by the law on status of the foreigners and non-citizens of Georgia, and no specific regulations are provided under the Labor Code of Georgia. So approach of the Georgian laws is mostly liberal. No specific requirements, for example, exist on hire certain numbers of certain number of local workers. So employer itself are quite free to hire any citizens. Employer are not required to hire a person, for example, owning work permit. It can hire everyone. And it has no liability to check the current status of presence of non-local, whether he or she has any permission to stay or work in Georgia. So there is no limitations are applicable on hiring non-locals as employees. There are some regulations in certain countries. For example, when investors coming in this country are required to, for example, hire a certain number of locals for going on with their businesses. Such limitations do not actually exist in Georgia. There are some specific limitations related to turnover of the employer, and we will talk about this later in our presentation. And this limitation mostly apply to citizens, to hiring citizens from certain countries. So citizens of the certain countries are allowed to enter Georgia without any visa and stay for 12 months without leaving country. And for staying them and working them in the territory of Georgia, no visa requirement or no work permit requirement, residence permit requirement is applicable for them. Among those countries are all EU countries, UK, Canada, USA, CIS countries, all CIS countries, including also Ukraine, and the employers are free to hire this person without any limitations, and which I talked previously, no turnover threshold will be applicable for that. For others, for the citizens of the countries other than these countries which I referred previously, and citizens of which can stay in Georgia for 12 months period, they are required, if they want to stay and work in Georgia, to enter country with a visa type D1. And generally, visa requirements in Georgia are quite, receiving visa for entrance into Georgia is quite a formal and straightforward everyone can apply and receive visa electronically through a certain portal, but receiving this D1 type visa is a different situation. A person, an individual who wants to come in Georgia and work here should apply personally to the respective Georgian embassy, and the Georgian embassy has around 30 days to issue D1 type visa after the relevant application by this individual. As soon as the person enters in the country, and the citizens of the countries which are not allowed to stay in Georgia for 12 months period, they should afterwards apply for their residence work permit. And the law directly provides some preconditions which allows this person to receive a residence work permit in Georgia. So in this case, the employee income should, salary of this employee should not be less than fivefold amount of the average consumer's subsistence amount. So this average consumer's subsistence amount is variable, and right now it's around 190 laris. So fivefold amount will be around 10,000 Georgian lari. And beside this, what I talked, there should be some preconditions from the employer's side. This precondition is that employer should have turnover about 50,000 per each employee seeking for the residence permit to stay in Georgia. For example, if the number of employees, non-local employees is 3, the annual turnover of this of the employer should be 150,000. This should be when applying to the agency. This should be somehow certified that this employer has this turnover. It can be done through providing maybe audited statement, or also bank account statements will be quite helpful in this case. This is not an actual income from economic activities. This is just a turnover on the company's bank accounts, because it may happen that the employer in this case is a non-commercial organization, and it does not have any kind of economic income or business income in the territory of Georgia. So they will be required to show on their accounts turnover around 50,000 Georgian lari for per each employee hired in foreign employee hired in the territory of Georgia. The exception is provided for educational or medical institutions. So, for example, their income, their turnover should not be less than GL 35,000 per each employee seeking for the residence work permit. So this information, when employee applies for the residence work permit, should be certified by the employer himself, and this information should be provided with the application by the employee itself. The person who applies for the residence work permit is an employee itself, and the authority in charge is legal entity of public law. This is Public Service Hall, and decision by this Public Service Hall should be made within 30 calendar days after application. So generally, when the person receives confirmation to stay in Georgia, in practice, the permit is issued for a 6 month period. It is up to 3 years can be, but generally they issue permission for only 6 month period, and this permission should be renewed every 6 months. So the person should not forget to go prior 40 days before expiration to go to the public service hall and request prolongation of his or her stay in the territory of Georgia. If it happens that there is a refusal, the person generally can stay in Georgia, can seek for a temporary extension of the stay in Georgia, and afterwards ask one more time, because it sometimes happens that on very formal grounds. So some citizens of the certain countries are refused to be granted this residence permit. And if person stays in Georgia, for example, employee stays in Georgia for more than 6 years, there is a strict requirement under the law that after the 6 years period expires, the person applies not for the temporary work permit, but only permanent permit for staying in the territory of Georgia. Those are general rules which apply to hiring the non-locals in the territory of Georgia. And just what should be taken into consideration is that just remember that the persons, individuals coming from the certain countries which can stay in Georgia for 12 months without any limitation, they can work here without any limitation. And no turnover requirement is applicable to the employer, and no requirement for applying for work residence permit is applicable to the employee. But any citizens of any other countries are required to come into the territory of Georgia, at least with the D1 type visa, and afterwards apply to the public service hall for the residence work permit to stay and work in Georgia. I think my part of the presentation is just over, and I will ask Bolorma Volodya from Mongolia office to go on with her presentation. I think she's here, and she will speak right now.
Okay, thank you, Sofia. And let me start my presentation. I am working in Grata International in Mongolian office, and today's my presentation will be about what kind of action can be undertaken by the employer during the COVID-19 pandemic. And the content of my presentation will be like, first of all, I would like to introduce what's the kind of legal definition of the employment agreement. And there's a number of the content requirements under the labor law of the Mongolia in order to be like employment agreement considered as a valid and effective agreement. And the second part of my presentation will be covering what kind of obligations employee or company have. And the next session will be, next section of my presentation will be what kind of measures can be undertaken by the employer during COVID-19. So it's basically, you know, like all the business is kind of directly or indirectly affected by COVID-19 pandemic. So for most of the companies, they have some concerns or might some questions how to minimize the cost during the COVID-19. And the last part of the presentation will be covering briefly, like what's the labor dispute trends in Mongolia, and what kind of the litigation is mostly resettled by the court proceedings. Okay, the employment relation is a part of the civil relations according to our legislations in Mongolia. And the employment relation is regulated by the Labor Code of Mongolia dated 1999. And as you know, that employment agreement is a binding document between the company and the employee. And generally, both parties need to have some obligations under the binding employment agreement. And I think it's the common in many countries that from the employee side needs to undertake certain daily duties, which is in compliance with the internal labor regulations, which is in compliance with the law. And from the employer side, they have to pay the salary to the employee based on the performance of the employee, and then needs to ensure the safe working conditions and other conditions agreed under the agreement. And also, there is a number of the legal requirements for the employment agreement under the Mongolian labor law. So if the one of the terms not agreed between the employee and employer, then the employment agreement cannot be considered as valid. So basically, there's 4 terms which is kind of mandated under the labor regulation that needs to be included in the employment agreement. And the first is name of the position should be specified clearly in the employment agreement. And secondly, daily duties needs to be specified, and it can be in the appendix of the job description of the employment agreement. So sometimes in the practice, some companies doesn't execute the job description separately. So what we recommend to our clients is job description is actually the part of the employment agreement, and it needs to be actually executed with the employee. And the next terms is what's the amount of the salary. And the last terms, which is mandatory to be included in the employment agreement, is working condition. So according to the relevant procedures, the working condition can be divided into normal and abnormal conditions. So this needs to be clearly specified on the employment agreement. And also, in practice, there's some companies and employers make a mistake that they're not making any amendments without, introducing to the employee. So it's actually prohibited under the labor law of the Mongolia that company cannot make any amendments, in its discretion. So the amendment of the employment agreement should be in written form and it needs to be signed by both parties of the employment agreement. And also, in order to define whether the employment agreement become effective or not, there's a requirement in the law that both parties needs to sign on that, and the employment agreement will be become effective. But there can be some exception that because of the urgency of the duties or works to be performed, then employee can start to work in the company or in the organization, but still, later employment agreement needs to be signed by both parties in written form. There are actually a number of the obligations for the employees under the labor code. So I just extracted some of the important obligations which the employer actually needs to fulfill. And if the obligation is not fulfilled, there is some penalty under the law of the offense, and also some can meet also the criminal kind of sanctions also. So first of all, every company is obliged to have internal labor procedures. So in the practice, some company actually, like maybe small and medium-sized companies, they don't care about to have an internal labor procedure, but it's kind of mandatory document which is required to have by the employer. And secondly, employee have a right to have a copy of the employment agreement. So it's a employer's obligation to give a copy of the employment agreement to the employee. And also, without a written employment agreement, the employer cannot demand the employee to perform any work and duties. And also, there's some restrictions, like for certain working condition and job positions, the minors cannot work. So when the employee is hiring new employees, they should be careful if the new employee is a minor. And also the employer is obliged to provide safe hygiene working conditions to the employees. On the previous slide, we actually mentioned about the employer's obligations under the Labor Code of Mongolia. And during the COVID-19, actually in Mongolia, we have a new law adopted in April this year. And basically this law is for preventing and fighting adverse social and economic impacts during the COVID-19 pandemic. So under the law, the companies have a number of the obligations also. And for example, they need to follow all the quarantine, traffic, and other restrictions regime, which is actually adopted by the competent authority. And secondly, the employee is obliged to keep the workplace of the employee who is in quarantine or traffic restriction or in isolation regime. So if the employee is, in the quarantine regime, means cannot travel and cannot go outside because of the government or emergency authority, then the company and employer needs to keep the workplace of the employees. And also the companies shall not organize any public event meetings during the quarantine and traffic restriction regime, and needs to provide, working environment by distance or using IT devices. So from the mid of the October, mid of the November, like until mid of the December, we have quite strict quarantine regime in Mongolia because of the COVID-19. And at that time, if the employee of any company is planning to terminate the employment, they need to actually have considered that what the obligations they do have under the law on COVID-19. Okay, the next section of the presentation will be like what kind of measures can be undertaken by the employee. So all these measures are actually given by the labor law of Mongolia, but some of the like last two measures can be agreed between the employee and the company. As you know, like the employment relation is between the company and the individuals, and the parties agreed to make amendments to the employment agreements. It's like there is a freedom of the contract that the parties can make amendments and to enforce the agreed amendments between them. So on the next slide is I will briefly talk all the measures one by one. The first of all, the company can give the grant annual holiday to the employee. According to our labor code, employee has a right to have paid annual leave for 15 days. And this 15 days can increase depending on the number of the years the employee worked and actually paid the social insurance premium. So because of the pandemic and because of the quarantine regime, if the employee cannot work from the office, and for some position and some jobs like the physical presence is required and to be performed, the daily duties from the office or from the factory workshop. In that case, the employer or company can better to give annual holiday as agreed with the employee. So, you know, if the quarantine regime is not so long or not many days, giving the annual leave is one of the best option to overcome short-term economic hardship and crisis. Next measures are like also given by the labor code that if the employee is not able to come to the workplace because of the natural or public disaster. So we actually see COVID-19 pandemic can be the one kind of the public disaster. Then the company can give 50% of the salary of the employee during the non-work period. Because, you know, if there is a quarantine regime and the traffic is kind of restricted, the employee cannot travel to the workplace. It's one of the way, you know, the employer or company can use this kind of payment to reducing the monthly salary by 50% and saving, you know, operational costs during that period. And another option that employee also can use is if there is actually no job or work to be performed by the employee, then company is entitled to transfer actually the business operation into idle time mode. In these circumstances, the salary of the employee can be reduced 60% or more during the certain idle time mode period. So this also will be one of the options the employee can use, also entitled to use under the labor code. But, you know, idle time mode is more like applicable that if there is no any work can be given by the company to be performed by the employee. So there's some kind of difference, you know, like when to apply which kind of option. It's like depending on the business of the company and what's the situation. So when choosing one of these options, the employer or company need to have a proper kind of legal advice. The next option which employee or company can use is termination of the employment agreement. But way before on the previous slides, we mentioned that under the law on COVID-19, the employer is obliged to keep the workplace of the employee who is in quarantine and traffic restriction regime. So by considering that conditions, still the employee decides to terminate, there's a certain procedure needs to be followed. And actually the termination of the employment can be done by because of the three legal grounds. So the first of all, if the company and its branch or its department has liquidated on the basis of the shareholders' decision or court decision, or the shareholder thinks that the business goal is already accomplished, then company may liquidate its branch or its department. In that case, this is the first ground to terminate the employment. And the second and third ground of the termination of the employment is actually abolished positions, means like within the organizational structure, some position is maybe not existing anymore because of the business demand or because of the operation of the company, or you know, like reducing the employee numbers. For example, there was two admins, then the company management decided they only need one admin, then the position number can be reduced. In that cases, termination of the employment can be initiated by the company. However, there's a certain precaution that company needs to consider is if the position is not existing, but after 3 months, maybe company management decided, okay, it's better to have a position, you know, restored in the structure of the company, then this action cannot be undertaken, because if the position, non-existing position has been kind of restored, the employment terminated employee can initiate the litigation at the court, and the court will be kind of reinstate his position back to the workplace. So if the company made a business decision that certain position not required, and maybe after some time, because of the business need, they need again this position back to the structure, it should be like at least after maybe 6 months. And then the company can hire the employee on that position. And as we talked about the 3 different kind of legal grounds, which can be initiated by the company to terminate the employment. Now we will talk about the procedures. So under the labor law of the Mongolia, we need actually the company and the employer needs to follow certain procedures. And first of all, employer shall give written notice on the termination of the employee to employee at least 30 days in advance. And if the company decided to terminate the employment 2 or more employees, like massive kind of redundancy, in that case, 45 days advance notice is required to be given to the employee. And the notice needs to be signed on the date of the handing over the termination notice. And actually, the company needs to give actually allow to work employees during the notice period. And also the redundancy payment should be 1 month average salary or more. And if there massive kind of redundancy, like company is planning to terminate 2 or more of employees at the same time, the employee has to make a negotiation on redundancy compensation with the representative of the employees. And after the notice period is passed, the director of the company needs to issue the resolution on employment termination. And at the same day, all this, the salary, annual leave payment, and average like redundancy allowance needs to be paid. And also the company is obliged to complete and provide social insurance booklets and on the same date of the termination. And if the employee needed some reference letter from the company or employer, it's the company's obligation to give reference letter to the employee. And in a practice, it's very common that, you know, the company make a mistake on these procedures, and they try to skip one of these steps. And because of that, the tendency of the labor dispute during at the court proceedings, the mostly company or employer is kind of fail because of the procedural mistake or error is made by them. And you know, company needs to check actually before the initiating termination of the employment. There is actually a number of the kind of exceptional or restriction that job or position of the employee needs to be retained. For example, if the employee is on annual leave, or employee is on a sick leave, or on maternity or pregnancy leave, and also the mother who has a child under 3 years old, then this kind of employees employment cannot be terminated as specified, in the labor code. So before the initiating the termination of the employment, the company needs to check all this restriction. Otherwise, it will be considered breach of the labor code. The last 2 measures which can be undertaken by the company during COVID-19 is the employee can reduce or postpone the salary payment, or to agree with the employee to give the unpaid leave. So this is a kind of the offer can be given from the company to the employee in order to, to overcome the financial or operational difficulties caused by the COVID-19 pandemic. So as mentioned before, the employee, if employee agrees to have amendments on these conditions with the company, then the written amendments needs to made between the employee and company, and also from the employee side, they need to understand, the business situations and this pandemic difficult condition, and can be negotiating on new kind of offer, which is offered by the company. So, but the company cannot push the employee and or cannot make a decision itself to make amendments on maybe the postpone the salary of the employee or to give unpaid leave. So it's like kind of mutual consent required on these measures. Okay, we come to the last session of the presentation, and actually this is there's some statistics number is we taken from the civil disputes resolved by the courts, and labor dispute is about 3.7% of the all civil disputes, and this number is belongs to the 2018 as a latest dispute statistics. And if we see what kind of dispute is more common are, first of all, unreasonable dismissal by the employee is a kind of the highest, about 49% of all the labor-related disputes. So, as mentioned before, that mostly the employer or the company make mistakes on the termination procedures, and they miss one of the steps we need to follow. And because of that, the unreasonable dismissal by the employee and its ratio among the labor dispute is quite high. And secondly, dispute on the compensation also quite high, it's about 38%. And the next ground of the labor dispute is incorrectly transferred from the work, like not getting, written permit or consent from the employee, like maybe employee has transferred employee to the other positions. But because of that, this kind of disputes actually happens. But, as comparing to the third quarter of the last year, labor dispute actually reduced by 18%. So it looks like, generally employment and labor related disputes number is reducing. Okay, I've finished my presentation, and thanks for your attention. And if you have any questions, we can cover them by answer and question session. So now my colleague from Baku office, Shabnam, she will present her presentation.
Thank you. My topic of discussion will be challenges and common mistakes faced by the employer during termination of the employment agreement. So let's first start with the primary source that regulate the individual relations between employee and employer. This is the Labor Code of the Republic of Azerbaijan that stands at the law governing termination of the employment relation, the grounds on which employment agreement can be terminated, and other aspects of the employment law. So employment code provides different grounds for termination of the employment agreement. And for the purposes of this discussion, I will divide them for three categories. First of them is the termination of the employment agreement at employee's initiative. Second one is the termination of the employment agreement at the employer's initiative, and other grounds for termination of the employment agreement. So we'll consider the grounds of the termination of an employment agreement at the employee's initiation. And among them, as can be seen from the slide, it's the termination of the employment agreement on the staff redundancy base. Sorry, I just, can you see the slides?
Yes, we can see.
All right, perfect. So I will continue. Yeah, so it can be termination, the grounds of termination of the employment agreement at the employer's initiation can be staff redundancy. It can be in case if employee doesn't pass the probation period, in case if employee doesn't carry out his obligation properly, or grossly violates the labor obligations. Another ground can be liquidation of the enterprise and others. So regardless of the ground of the dismissal of the employee, the termination must be properly documented. The ground of the termination must be justified and proved if necessary, and such a dismissal must comply with the procedural requirements. So sometimes in practice, there might be several reasons for termination from one hand, and from another hand, there might be a limitation in the labor code, and this is explicitly stated in Article 76.1 of the Labor Code that state that employment agreement can be.
Sorry for interrupting you. Could you please just click on разрешить редактирование? Something is wrong, I think, with your.
Pardon?
Could you click on разрешить редактирование? I think yes.
All right. Can you see now? Sophia?
No, I just see you.
All right, let's try again. Can you see now?
Yes.
All right.
Okay.
So I can move on. All right. Sorry for technical issues. So yeah, as I mentioned that employment labor code can provide several reasons for termination of the employment agreement. However, in practice, there might be several reasons for termination of employment agreement. However, labor code prohibits to terminate such agreements for several reasons, and there might be only one reason for termination of the employment agreement. So what we can see in practice, there might be cases when there might be ground of termination of the employment agreement either on expiration of its term or on staff redundancy ground. So in such kind of cases, we just recommend to pick up the less risky one. And we will advise in this situation to terminate the employment agreement on expiration of its term. And you might wonder the reason. Firstly, termination of the employment agreement on expiration of its term, it's straightforward compared to the termination of employment agreement on the base of staff redundancy. Secondly, you might be aware that during termination of employment agreement on staff redundancy ground, there are some severance payment that must be paid to the employee during termination, which might be quite costly. So for these reasons, we just advise to go on with expiration of the term ground. Another example might be that there might exist termination of the employment agreement on staff redundancy ground and on mutual consent ground. And if it won't be possible to reach agreement with the employee, then of course the applicable will be the staff redundancy. So what we witness in practice is that sometimes, unfortunately, not all employers possess the required information about their employees. So there are some protected groups of the employees with whom employment agreement cannot be terminated under staff redundancy ground. So this is mainly pregnant women and women with their child under age 3, men upbringing independent with the child under 3, temporarily disabled employees, employees on vacation or on business trip, and other group of employees, as you can see from the slide. Concerns in practice are also come up when on COVID-19 impact on the employment agreements. So as everybody knows, COVID-19 had huge impacts on global markets. Some employers had to take a business decision to shut down their offices in different jurisdictions, to reduce salaries, to lay off their employees. And the common question that we received during this time period is whether employment agreement can be terminated on staff redundancy ground during a pandemic. Actually, we understand what leads to concern about the legitimacy of staff redundancy action. So this is the decision of the cabinet ministers of the Republic of Azerbaijan, where they stated that they stated that employment agreement, they just recommended to the private companies to not to refrain from terminating the employment agreement with their employees on staff redundancy ground. Again, this was just a recommendation, and this is not a restriction. And during 2020, we had a lot of lawsuits that was brought by employees, by ex-employees against their employer. And they mainly were referring that their dismissal, the ground of dismissal was unlawful, just because the decision of the cabinet of ministers for them were just restricting to terminate employment agreement. However, having in mind that employer complied with all procedural requirements and the ground of termination was selected lawfully, we proved that the termination of the employment agreement actually was lawful, and the decision of the cabinet minister and a presenter degree wasn't a bar. Another common question that we receive is that whether employment, it's about what to do whenever the employment agreement is expired. However, the employee is under sick leave, is infected with COVID-19. So in this kind of situation, firstly, we need to highlight that infected with COVID-19 employee will be considered as employee who temporarily lost his, will be considered as employee with temporal disability. And if there is a valid medical certificate confirming his absence confirming his absence from the workplace, then employment agreement can be terminated only after his or her recovery, and when within a week after he starts his job duties. Actually, in practice, we can also see that unfortunately not all employers comply with the procedural requirements, with the formalities. One of them comes up with the documentation requirements, and Article 83 of the Labor Code state that regardless of the ground of termination of the employment agreement, there must be order, such termination must be done by the order of the employer or decision or decree, and there is some requirements regarding the content of the order, which stated in Article 84.1. As per Article 84.1, the order must include information regarding the name of the enterprise, its legal address, position and name of the employer, the full name of the employee, the grounds for terminating the employment contract, the relevant article, part of the article, clause, and other information as stated on the slide. So if order doesn't comply with the procedural requirements, such an order might be deemed invalid, and during the court hearing, such termination might be considered as unlawful. And during the employment law audits, we usually face that employers actually do not follow these procedural requirements. Another mistake comes up with the untimely payment of the wage. So this is also procedural requirements, and as per which the employer is obliged to make payments to the employee on his last working day. So it's not next business day or the week following the termination of the employment. So termination, another common mistake comes up with the termination of employment agreement during a vacation. We also have a recent case whenever employee committed actually a theft during at the workplace, and everything was properly documented. The ground of termination was reasoned. And there were some strong evidences such as video records and etc. So what was done is that employer just terminated employment agreement of the employee during his vacation. For this tiny mistake, the employment the termination of the employment agreement was ruled unlawful by the judge. So the mistakes also can be seen whenever it comes to providing the employees with the notice letters. Not all employers provide the notice letters in a timely manner. So notice letters are mainly relates during termination of the employment agreement on staff redundancy ground. And this is also a procedural requirement. If an employee work at the company for, let's say, 3 years period, then notice letter must be provided to the employee at least for calendar weeks in advance. If employees year of service will be more than 10 years, then it must be at least 9 calendar weeks in advance. So to sum up the presentation, just to avoid any disputes and any administrative sanctions, we just advise to comply with the procedural requirements of the labor code. Thank you for your attention.
Thank you, Shabnam. So this is the last part of our sessions, questions to our speakers, and I will start with Azerbaijan. There was a question on Azerbaijan presentation, and I will read it to you. We fired the employees on staff redundancy ground. We paid all statutory compensations. compensations. One of them filed a lawsuit asking the court to reinstate him at the position. The main argument is that we employed a new employee to his position. How likely is he to be successful, taking into account that we made all notices on time, paid full compensation amount, plus compensation for unused annual leaves? So can we answer this?
Sure, we can answer that. And firstly, I would like to say that unfortunately, we can't definitely provide the right answer for this because we are not familiar with the facts and the documents of the matter. But what can I say from the labor law requirement is that labor code, unfortunately, doesn't regulate the matter concerning actually when employee should hire the new employee for the position that was, I believe, cancelled due to staff redundancy. So if the position wasn't cancelled or revoked by the employer, I believe, and this is coming from the practice, the employee might be reinstated at his or on her workplace.
Approximately similar attitude is in Georgia in this case. For example, if the place has not been actually cancelled by the employer, it means that if the former employee goes to the court, he may win the case, but the person cannot be restored in its previous position. The court practice developed in such manner that this person is paid actually the compensation. So I will ask Bulurma if she can answer in this question with Mongolia practice as well, because it's a quite common ground of employment claims, and if she wants, of course.
Sophia, can you repeat the question? I missed some of the part.
It is a situation when an employer terminates the agreement on redundancy grounds and hires just in a short period of time another employee, and the former employee goes to the court and claims to be restored, and it's on his previous position. So what may happen in this case in Mongolia?
Actually, the company decided to remove the position from the org chart. Like for 3 months, the position cannot be restored in the structure of the company again. And, within 3 months' time, if the company had the same position again, and the employee whose employment is terminated knows about that, he or she can go to the court, and court will be like oblige the company to rehire the previous employee back to the position. So it's kind of similar, I think, like it's kind of protecting the employee rights. And the mostly in that case, the company actually failed during the court proceedings if they taken such kind of action.
There was a question for Georgia. As we are required to have a new foreign employee in Georgia at the time of submission of an application, are we required to have a new foreign employee in Georgia at the time of submission of an application for work and the residence permit. Are there any exceptions for COVID-19 quarantine period? So actually what happens in Georgia is that yes, at the moment of application, there should be an employment agreement. At least it should be a conditional employment agreement. For example, if this person receives residence work permit, he or she will be hired as an employee in Georgia. So this agreement should be attached actually to the application, because this application I have mentioned should be submitted by the employee. And so, yes, the answer is that, yes, the employee should be on place, and employment agreement should be on place as well. What about COVID-19 regulations? It's a situation, for example, when we have a regulation, temporary order that foreign citizens for which the residence permit has expired can stay in Georgia on legal grounds till the end of the year in case they cannot leave the country, and in case the situation in their countries COVID situation in their countries are worse than in Georgia. So I think just a few countries right now which has a worse situation than Georgia, but still this regulation exists, and the approach is quite liberal actually on these grounds. The individuals who applied for prolongation their stay in Georgia, their prolongation applications were satisfied. So if the employee has entered already in Georgia and its a work or residence permit expires, he can stay to the end of this year. And I think this time should be extended for several months after the end of December as well. So I think this question might be of interest for other jurisdictions as well, and if Balorma or Shaman wants, they can answer on this as well. Okay, so I will go with extra question on Georgia. On what grounds can the applicant be refused a work residence permit in Georgia? There are some formal grounds under the law. These are when the grounds for receiving this work permit does not exist anymore. For example, the person is not employed in the territory of Georgia. But in our practice, when a person is refused to stay in Georgia, is that there are some security, public security threats due to activities of this person, and this ground is used quite often in Georgia. And in practice, when we apply to the agency whether they should provide more detailed grounds, they just refuse. And in this case, when we go to the court, we just require through the court the grounds and understand what are behind this formal refusal grounds. And so this is the situation here in Georgia. And I also want to ask some question about all jurisdiction. For example, can an employer demand from employee to go on paid leave due to the COVID pandemic, also in case when employee is infected, for example, with coronavirus? Just maybe Bolorma or Shabnem can answer this.
Can you repeat the question, please, Sophia?
Can an employer demand from employee to go on unpaid leave due to the COVID pandemic, also in case when the employee is infected with coronavirus?
Well, all right, I will just answer this question. So basically, vacation can be formed on the mutual consent, on the request of the employee and by the confirmation of the employer. So, the labor code prohibits to send employee on vacation without the will of the employee. So basically the answer will be that employer can't demand that. That might be formed on the mutual consent base.
Okay, for Mongolia is actually employee is sick of the coronavirus, and I assume that the employee is in maybe in a hospital or in an isolation regime. So in that case, the company needs to keep the workplace. And in terms of the, that, like the demanding to have the unpaid leave is also kind of, it should be mutually agreed. Otherwise, the company cannot make this decision itself that, you know, you should take unpaid leave. So maybe there can be some discussion between the employee and the company, and they can agree other kind of terms between them, like maybe reducing the salary or some other kind of option can be agreed between the parties. But the company is obliged to keep the workplace of the employee.
In Georgia, situation also the same, just on unpaid leave, the person can go on the basis of mutual agreement. The employer cannot unilaterally decide to decide on unpaid leave of the employee. So there is a question, I think it's a general question to everyone, how to dismiss while the employee on sick leave or maternity leave, actually on any leaves, if it is important for the company to actually fill the position to be working. This is a question from Valentina, and I will ask Shabnam or Shabnam, please answer this.
Sophia, I really apologize. Can you please repeat the question? I believe there is some connection problem and your voice is missing.
Okay. How to dismiss while the employee is on sick leave or maternity leave, actually on any leave, if it is important for the company to actually fill the position to be working. Is it clear right now?
Yeah, perfectly clear. Thank you. So basically, in Azerbaijan, the situation is that the employee who is pregnant, or if the employee is sick, whether it's COVID-19 or for other illness, this kind of employees cannot be dismissed from their workplace. It's prohibited by the labor code of the Republic of Azerbaijan, and I previously mentioned that during my presentation. And the workplace position and salary of these employees are preserved by the labor code.
Thank you, Shabnam. Palorma, please.
For Mongolia, it's same. Yeah, because for the employee who's on maternity leave or in the sick leave, the company need to keep the workplace of these employees, and dismissal or the termination of the employment cannot be, you know, undertaken by the company side. And if there's a business needs to refill those positions, I think the company can hire some employees for the certain period of time, and the employment agreement with the term can be executed between that temporary employee and the company.
Same attitude as in Georgia. You cannot dismiss a person who is on sick leave or on maternity leave. The position is preserved for this person. In such case, solution might be to fill this position on the ground of temporary labor agreement with any other person. So in Georgia, such situation is a grant for entering into a temporary labor agreement. There is another question specifically for Mongolia. It is the question for Bolorman. Now we are in full lockdown and some of the employees can't work from home. Drivers, receptionists, we put them in 50% of base salary, but by 66.1. Is this okay to use this clause or should we use 56.1?
What's the last paragraph was missing? Your sound was like not clear.
As I understand, there are references to the provisions of the Mongolian labor law, and the question is that can we put them in 50% of base salary by 66.1, and is this okay to use this clause, or should we use 56.1? Is it clear?
I think so. The 66.2 is about natural disaster or some other reasons. The employee cannot come to workplace and work, then 50% will be paid by the company as a compensation. But this clause is more applicable during the quarantine regime. And according to the latest information that from Monday, the quarantine regime will be kind of loosened, and some of the sectors, some companies can operate normally. So until maybe until 12th of December, this 50% compensation can apply. And if the employee or company want to use idle time regime, the compensation will be the minimum 60% of salary, then it also can be decision can be taken by the company. But in this case, the company doesn't have any work, as I understood, the company business is down. Then I think the company make a decision based on the idle time mode, and the compensation of the salary will can be reduced to up to 60% of the monthly salary of the employee. So once the quarantine regime is kind of have to say more kind of reducing from next Monday, then they can make a decision that 50% of the compensation can become as a 60% of the compensation for this for some time, until the company operation restored and run normally.
Omar, thank you. Another question. While period of COVID, the work scope of some employees is increased. How to deal with the employer if the employer does not hire the new personnel and does not restructure the company personnel and not paying OT for the employees working extra hours to high volume of jobs. So I think this is the question about overtime compensation mandatory requirement. So I will ask Shabnam to answer this question because this is not specifically addressed to any jurisdictions, and I think we will answer all.
Yeah, right, sure. So basically, right, Sophia, as you mentioned, the overtime payment and overtime payment explicitly, I see that they explicitly state overtime. The employee has the right to be paid for extra work. and not fulfillment of this obligation by the employer will be considered as the breach of the right of employees and might lead to the administrative penalties. In this case, the employee can simply complain this action of the employer to the state employment agency in the country, or if there is a labor union within the company, they can submit their complaint there.
Shabnam, thank you. Balorma, please. And
the general kind of the principles under the labor code of Mongolia, if the employee is worked overtime, like more than 8 hours per day, the employee can entitled to get paid for the overtime. And if the company is not willing to pay that, also he can the employee can protect his rights and to submit a complaint to the competent authority to protect his or her rights.
Thank you. Under the current wording of the Labor Code of Georgia, the overtime should be compensated on increased hourly rate on the basis of the agreement of the parties of the employment contract. So the parties may agree on overtime remuneration under the employment law in Georgia. And also another solution that the law proposes is just granting extra day offs to the employee if the employer agrees on it. So this might be either compensation or extra holidays for the employee. Another question is that if the employee in annual leave for a long time, mostly an unpaid leave, what about the calculation of paid leave? Those days should be removed or should be removed, or they should be count as earned leave days. So if the question is that if the employee is on a long unpaid leave, in such case, what about the calculation of paid leave days? Should they be calculated in such circumstances? Can employer is employer entitled to remove these days, or they should be counted as earned leave days, despite the situation that this person was on unpaid leave for a long period of time? Please, Balorma, if you can answer this.
I think from the question, I understood that actually the employee was unpaid leave. So it means that he or she doesn't work for quite some time. And then maybe the employee joined back to the job and want to get, I think, the annual leave payment. So we actually do have a procedures how to make the calculation of the annual payments in Mongolia. So the general principle is the average of the last 3 months salary will be used for calculating the annual leave payment. This is the general principle.
Thank you, Shabnam.
So if I understand the question correctly, the employee was on unpaid leave and they wonder whether upon coming back to the work, they will be paid for that duration. If my understanding is correct, unpaid leave, the leave that is not that's not paying to the employee, and if employee is back and wanna get annual leave, then of course it will be paid. If I just correctly pick up the question, the answer will be this.
The answer is mostly similar with respect of Georgia. For example, if a person is on the sick leave, for example, if the person is on the sick leave for more than 40 days, this might become a ground for termination of the employment. But if the employment has not been terminated, in such case, the employee is still entitled to use its paid leave without any limitations, which is under the labor code of Georgia, cannot be less than 24 working days.
Sophia, I just like to comment something on this. In our country, if employee is on the leave for more than 6 months, then employer has a right to terminate employment agreement with such an employee. It's just a comment.
Another question is about the scope of employment relations. It's to Shabnam, and I think it would be fine if Bolorma answers this as well. Do the local employment laws that regulate the employment relationship apply to foreign nationals working in your jurisdiction and nationals of our jurisdictions, of your jurisdiction working abroad? Shabnam, please.
Yeah, thank you for the question. So if employee is foreigner, there are just some principles to follow. If employee is a foreigner and signed employment agreement abroad and will perform his or her job duties in the branch or representative office of that foreign company, in that case, the labor code will not be applicable to such employee. Regarding the citizens of our country which are working abroad, if they are signing employment agreement with foreign employee, and if the governing law will be picked up as a foreign law, then employment labor code won't be applicable in this case.
Okay, for Mongolia, I think for the expatriates or foreign citizens who are working in Mongolia under the employment agreement, then our labor code will apply for those foreign employees. And similar to the Azerbaijan, like if the Mongolian national is working in other countries and they do have like employment agreement with the foreign company under the such countries labor law or regulations, then our labor code will not apply for that case.
Bolorma, thank you. In Georgia, the employment regulations, mandatory employment regulations, is applicable in any case if the employment actually is carried out in the territory of Georgia. So, main duties of the employee, the main duties of the employee is carried out in Georgia. It doesn't matter this employee is Georgian citizen or foreign citizen. The mandatory requirement of the employment law is still are still applicable, and the situation is different than the if the employment is not actually carried out in Georgia. In this case, just definitely Georgian law does not apply. So this should be assessed on the actual on the basis of actual assessment of the nature of the employment relationships itself. And the answers in this case cannot be quite straightforward, yes or no. It requires just some kind of comprehensive analysis where the employment actually takes place. There is a question from Dushanbe to all participants. I will read this question. The labor code Code has not made retirement age mandatory. We wish to retire employees who have reached recommended age as per organization staff regulations. However, the employee is resisting. How can we have a smooth separation? Shabnam, please. Shabnam, please switch on your microphone.
Yeah, done. I will just get familiarized with the question. Just a few seconds.
Sorry, do you want me to repeat the question?
Yeah, please.
Okay, so the labor code has not made retirement hasn't made the retirement age mandatory. We wish to retire employees who have reached recommended age as per organization staff regulations. However, the employee is resisting. How can we have a smooth separation?
All right, perfect. Thank you for the question. So first of all, in Azerbaijan, a labor code provides the dismissal upon reaching a limited age only on the initiation of the employer if the company is state-funded organization. Otherwise, if employer wish to just dismiss employee because of reaching him or her his limited age. In that case, this might consider under the labor code as a discrimination on the age. So to keep such dismissal smooth, we advise either to reach agreement with the employee or check whether his employment agreement is due to expire and terminate employment agreement on expiration of its term. That will be my answer to the question.
Thank you, Shabnam. Balarma?
In Mongolia, the retirement age is 60. Generally, age kind of limit to retire is 60. So for the company and the employer have a right to initiate the termination of the employment if the employee has reached 60 years old. And there is no kind of such a restriction, you know, it's like a company have a right to initiate the termination.
Okay, thank you. So I think in Georgia, the answer is similar to what happens in Azerbaijan with slight differences maybe. Reaching the retirement age is not ground for termination of the employment relationships. So on this ground, the employer cannot terminate the agreement. And which is more important and case in our regulations is that any employment agreement which actually lasted for more than 30 months means that this employment agreement is entered for indefinite period, and there must be the certain grounds for termination of this employment agreement. So those grounds are quite exhaustive, and no other grounds can be applicable in case of termination. So if this person, and actually if the person reached the age of retirement in this company and worked quite long, just a smoother separation is possible only on the basis of mutual agreements of the employment contract parties. So I think the questions, there are no more questions. If someone still has any question, just I do not see any additional. So I would like to thank you all participants. So as I mentioned in my welcoming speech, that this is the last session of our conference, and this is it is over with those Oh, sorry, there is one additional question from Dushanbe. So this is also, I think, the last one. So we have to reduce one position from a department of 3 employees. 2 of them have just returned from maternity leave, and 1 of them has a fixed-term contract. The 3rd employee has open-ended contract. The maternity cases are protected by law. In this case, can we terminate redundancy? The employee who has open-ended contract vis-a-vis maternity case, who has fixed term a fixed term contract. So is it, the question is clear, or should I repeat it?
Is it a company or department is going to be liquidated?
I don't know. No.
I think in the beginning there was some kind of conditions that, like.
Just a minute. We have to reduce one position. It is a one position from a department of 3 employees. This is a precondition. Just one position from a department. And the redundancy is due to budget issues and a reduction of activities.
Okay. The mother and the single father who has a child with the age under 3, the dismissal of the employment is prohibited, by the initiative of the company or the employer. So for the 2, I think I understood 2 employee was just come back from maternity leave. So it means they have a child under 3 years old, so they are protected actually. So termination or dismissal of the employment cannot be initiated by the company. So the 3rd one, who is working on a fixed term, then I think the company needs to talk that employee, and then maybe that person can be dismiss the employment. But there was some kind of, the question was kind of some quite many kind of conditions mentioned, so maybe I missed some of them. So whether my answer is sufficient enough, I'm not sure.
So, Balrama, we have almost the same approach. If the employee, especially woman, has a child under the age of 3, she falls under the protected category, and the termination of employment contract with this employee on the staff redundancy ground is not possible. The only applicable will be is a liquidation of the enterprise or the expiration of the term of the employment agreement.
Thank you, Shubnam. In Georgia, if there is a staff redundancy, actually it can trigger termination as open-ended employment contract, as well as the employment contract entered for the certain period of time. But there should be just clear grounds for such termination, and the reasoning also should be quite clear why the employee chooses this specific person, and why this employer terminates the agreement with this specific employee. What was the precondition for making the choices in this case? Okay, I think there were some extra details about factual circumstances related to the questions. I questioned this question specifically. I think we can answer later, maybe in writing. I think today's session and this conference is over. And I would like to thank you all participants, and we will send all materials to you. Now, as I know, we have all emails of all participants, and we can provide them with the materials. And I think we can, if there were some questions or some clarifications are needed, just maybe you feel free to reach us anytime. So thank you very much. Thank you, Shabnam. Thank you, Balormam.
Thank you.
For your interesting presentations, and thank you to all participants.
Yeah, thank you for participation, and wish everyone to have a nice day.
Thanks.
Thank you, everyone.